Key employment-based immigration law updates for October 2025. That's what we're talking about on today's Live at Lunch. My name is Emily Sumner with Sumner Immigration Law, and I'm so glad that you are joining us, whether you're joining us live or catching the replay. If you have questions about what we're talking about today, key employment-based immigration updates that will affect both employers and foreign nationals and their loved ones in October 2025 and going forward, put those questions in the comments, and I'm happy to address them if I can, either now, live while I'm talking, or if you're seeing this later, go ahead and put those questions in the comments, and I'm happy to address them as I can. As always, this information is not legal advice. It's intended for educational and informational purposes only. So today is September 30th, 2025, and it has been just over a week since Trump's proclamation about the $100,000 fee for H-1Bs. So I want to touch on that, give some quick updates on that, to talk about two proposed regulations that are actually out, another proposed regulation that is probably coming down the pipeline that will affect H-1Bs and other LCA-based petitions, and talk quickly about the October 2025 visa bulletin. So let's get into it. So first of all, the $100,000 H-1B fee. There, as you know, there was a lot of panic and chaos and lots of stress and anxiety floating around surrounding the proclamation that was suddenly dropped on Friday a week ago about the $100,000 fee that was allegedly is required for some H-1Bs. The way that the headline came out made it seem like this $100,000 fee would be applicable to every H-1B that's filed. Unfortunately, that is not the case. We have additional information now through the proclamation itself and through subsequent updates, and perhaps just as importantly, if not more importantly, through on-the-ground practical experience that we have seen from our clients directly and that we've heard of from other immigration attorneys. So what we know is that the H-1B $100,000 fee only applies to petitions that were filed on or after September 21st, 2025. So importantly, we are getting lots of questions, understandably, from individuals that filed H-1B petitions prior to that, whether they were H-1B cap petitions, extensions, transfers, whatever they were. And the proclamation is clear that the $100,000 fee does not apply if your H-1B petition was filed prior to September 21st, 2025. So that's good news. We do have unanswered questions based on the information from the proclamation. Some of the wording is not clear, and unfortunately, we just don't have clear guidance from the government as of right now. But what we do know from practical experience is a couple of things. What we know from practical experience is that our office and other immigration attorneys across the country have filed a number of petitions, new petitions, H-1B petitions. And when I say new, we have filed a couple of petitions that are for requesting a change of status. So in that sense, they're new. They're new, meaning the person has never held H-1B status before. We have filed those. Other immigration attorneys across the country have filed those. So far, those are being reseated, and we're not seeing requests for the $100,000 fee. Importantly, in those cases, the individuals, the foreign national beneficiaries, the people for whom these petitions are being filed, are physically present in the United States right now in another visa classification. I do think that if a beneficiary is outside of the United States and a new petition is filed and they have to request, they have to apply for an H-1B visa, I do think in those situations that the $100,000 fee may be applicable, assuming they don't fall under the national interest exception. And we don't have any more guidance on what that could be either than we have previously. So my point is that for individuals who are in the United States requesting a change of status, it has not, the $100,000 fee so far has not been applied. I don't think it will be. The reason I say that is the legal underpinning behind this proclamation is, and I mentioned this last week, but the legal underpinning is the Immigration and Nationality Act, Section 212F. It is a part of the law, the statute that Congress passed, that says, and I'm paraphrasing here, that the president has the ability to restrict the entrance of certain foreign nationals into the United States on the basis of of national security concerns. It's broadly worded, but that is a legal basis, at least ostensibly, arguably, under which a president could restrict the entrance of certain foreign nationals into the United States. So that is a legal basis. It's not that the president is, whether I agree with it or not, it's not as if the president has just pulled this out of nowhere. However, that Section 212F, that ability to restrict the entrance of a foreign national, only applies to individuals entering or attempting to enter the United States. That's why I think personally that this will not apply. And I could be totally wrong. We'll see. But personally, I don't think that this $100,000 fee will apply to individuals who are already in the United States, where we're filing a change of status, or employers are filing a change of status from some other visa classification, like F1, for example, or TN, or any number of other visa classifications to H1B. I don't think that the fee will be applicable in that particular case. In addition, our office and lots of other immigration attorneys across the country have continued to file H-1B petitions for transfers, amendments, extensions, that type of thing, and the fee has not, they've been reseated and the fee has not been requested. The wording of the proclamation is such that I think that the fee would not apply in that situation. They talk about new petitions and they talk about situations where the foreign national beneficiary is outside of the United States. So it's still not a great change, but it is limited in scope. This proclamation is limited in scope, and we will continue to keep you posted on developments there and on litigation. I haven't seen a lot of information so far about litigation, but except that there are attorneys, litigators who are looking for affected individuals to go ahead and get those suits filed. So the next thing that I want to talk about is a couple, and I'm looking over here because I wrote a blog post this weekend actually about this. So I'm using that as my notes, and I'll try to remember to put that link in the comments here so you can read if you prefer that. But there are two proposed regulations that are out that I want to talk about. One is the proposed rule that would affect the F1 and J1 categories. That is a long proposal. That proposal is out. So to back up for a minute, I talked about Section 2A, INA 212F. That's part of the statute, which is part of the law that Congress passes. Regulations are rules that the agencies come up with themselves. So Department of Homeland Security will come up with rules. The Department of Labor has a set of rules or regulations. I'm using rules and regulations interchangeably here. Every agency has their own set of regulations, which is their implementation of the statute, supposedly, hopefully. And it's supposed to be aligned, within the confines of the statute, the way that they implement them. So anyway, the Department of Homeland Security has published a proposed rule that would bring a lot of changes to the F1, which is the foreign national student classification, and the J1 visa classification. The J1 is used to facilitate intercultural exchange, and it's used for all sorts of purposes, including to facilitate long-term and short-term research scholars, au pairs, some teachers. The J1 is used for interns and trainees. So my point is this proposed rule has significant implications for a large group of people, unfortunately. So the key changes, and like I said, there are a lot of changes. So this is by no means all of the changes, but some of the key changes include duration of status. So right now, if a person enters the United States on F or J, they are admitted for what is annotated on their I-94 as D/S. That means duration of status. That means as long as their program is in place, as long as their program lasts, they are in status for that duration, assuming they're doing the things to stay in status, like attending classes full-time, that type of thing. The proposed regulation would change that to give a specific end date, and the specific end date would be no longer than 4 years total. In addition, part of the proposal is to reduce the F1, this foreign student grace period, from 60 days to 30 days, and to institute changes on educational level changes. So basically, F1 students who complete a degree program would not be able to start a new degree program at the same or lower educational level. The comment period ended yesterday on September 30th. So from here, the agency, Department of Homeland Security, is supposed to review all of the comments, and they don't have to agree with the comments, and they don't have to incorporate the suggestions that various people have into the regulations, but they do have to review the comments and then publish what is called a final rule with a notice period. So the final rule will be published. We don't know exactly when, but the final rule will be published, and then there will be a period of time before it actually becomes effective. It could become effective before the end of the year, and these are significant changes that will affect, of course, foreign national students and those on J1, but also those who employ them as well. So a lot of changes coming up potentially in that area. The other proposed rule that is out there affects the weighted selection for the H-1B lottery. So the H-1B lottery, as you may know, is a lottery that happens almost every year, but definitely in the past several years, I would say even 10 years, possibly. Yeah. There's been an H-1B lottery, meaning individuals or companies, rather employers, who want to sponsor someone for an H-1B actually register the foreign national beneficiary in a lottery. The lottery is conducted the end of March. Thus far, the lottery has been conducted just randomly, just random selections. So it does all the time. People have asked me, and it's been a great question. People have asked me, hey, do I have a higher chance of being selected because I have this type of degree or because I'm in this profession where there's a shortage or things like that? And the answer has been no. That is potentially going to change, assuming this regulation goes through without significant changes. This regulation, the proposed rule for the weighted selection for the H-1B lottery cap, the H-1B cap lottery says the current version is that the entrance, the registration, in other words, into the H-1B lottery would also have to include information on the salary being offered, the standard occupational code in which the person would work, and the geographic location. Right now, that information is not included. So there would have to be a lot more strategic analysis done by us as immigration attorneys before we enter the case into the system. Right now, we do some initial analysis for sure. We want to make sure that a person is actually qualified for the position being offered and that it's a position that is H-1B worthy, meaning a position that requires at least a minimum and a bachelor's degree in a specific field of study. But we don't necessarily help the employer figure out what the proffered wage is going to be in the standard occupational code. That's more granular analysis and strategy that we do once the petition has been selected. So that's the big change here, is we would have to do that work up front. How this would look in practicality is that USCIS would look at the proffered wage, the wage being offered to the foreign national beneficiary, and they say that a beneficiary that is assigned a wage level 4. So when I say wage level 4, there are 4 wage levels for any given standard occupational code. They say that a beneficiary assigned wage level 4 will be entered into the selection pool 4 times. If it's wage level 3, they'll be entered 3 times. Wage level 2, they'll be entered 2 times. And wage level 1, they'll be entered once. So then the chance of selection would be higher the higher the wage level is. And I'm oversimplifying that a bit, but that's the bottom line. This would significantly change, like I said, the way that registrations are prepared. And of course, ostensibly that it would affect the chances of being selected in the H-1B lottery, depending on those factors, the wage, the standard occupational code, and the geographic area, and namely the wage, or primarily the wage. So this is something to keep an eye on. The proposed rule is out. The comment period ends 30 days from September 24th. And then, as with the other rule, the agency, the Department of Homeland Security, has to review those comments and will then publish a final rule. It is possible that this rule will be out before the registration period begins in March of 2026. So another change to be aware of, and we'll keep you posted as things develop. The other proposed rule that is kind of floating around that the administration has said is coming is a proposed rule that would change the prevailing wage system. So the first Trump administration tried to do this as well, where they did this. And I believe it was struck down by the federal courts. It did not go into effect. And I think there would be challenges for a number of these, litigation for a number of these if and when they come into effect. But anyway, the proposed rule that is in the pipeline, but the proposed rule has not been published yet, but it's coming. They say it's coming, is a proposed rule that would change the prevailing wage system. I don't have more information than that, other than to say I think it would increase the prevailing wages. The prevailing wages are the wages that the Department of Labor sets for any given standard occupational code, and it's based on geographic area. And it's set to protect the salary of the foreign national workers and to protect U.S. workers. So it's set to protect U.S. workers from having a situation where a foreign national worker is hired and is underpaid. So anyway, that proposal is in the pipeline. We'll publish more information about that, share more information about that once we have that information. The final thing that I wanted to touch on, and I talked about this a couple of weeks ago before all this happened with the H-1B $100,000 fee rule, or proclamation rather, is the October 2025 visa bulletin is out, and as of tomorrow, it's live, meaning if you are eligible to file the I-485 under the October visa bulletin, then you can file that I-485 starting tomorrow. So that is exciting. I know there are a number of people who are affected and are really excited to be able to file the I-485. So if you need help with that, let us know. Or if you have questions about any other employment-based or family-based immigration matter, let us know. Put those in the comments and we're happy to help. If you are looking for an immigration attorney to help you navigate the system, we are here. You do not have to do this alone. There are lots and lots of changes that are out right now. Some of the changes are regulatory changes. Some of them are just policy changes or even unspoken changes. So there's a lot to navigate and you don't have to do it alone. We are here to help you. So if you're looking for an immigration attorney, feel free to contact us. Our contact information, including a link to set a time for a consultation, will be on the outro slide, which we'll follow in just a minute. Otherwise, if you found this information helpful, I hope that you will share it with a friend or family member. Share this video with a friend or family member, like it, comment on it so that other people are able to find it, and make sure that you are subscribed to this channel with alerts on so you don't miss our next video. I hope you'll join us next week for our Live at Lunch Tuesday at noon. Until next time, my name is Emily Sumner with Sumner Immigration Law. We serve clients around the world and around the United States with employment-based and family-based immigration matters. Until next time.